Now, tonight on our front, we dive into this heated legal and political debate following the opposition New Patriotic Party's press conference today, where they raised concerns about actions they believe threaten due process, human rights, judicial independence, and the democracy here in the Republic of Ghana. At the heart of the discussion are four major developments. First, the Mahama government's directive to sack all government appointees engaged after December 7, a move that raises questions about continuity in governance and legal employment rights. Also, we'll be exploring the powers of the Attorney General to enter what has been more recently developed as a nolle prosequi, and under what conditions should this be excised in light of the recent actions of Dr. Dominic Ayine. The removal of CEOs of state institutions following the new government's takeover will also be part of our conversation this evening. And more than just that, we'll also be jumping into other conversations here on the show, which will be the Office of the Special Prosecutor's invitation to former Finance Minister Ken Ofori-Atta and the controversial claim that the OSP lacks the power to declare him a fugitive, which is what the MPP stated earlier. Now, we will proceed on that length. The MPP has already described the OSP's declaration of Mr. Ofori-Atta as a wanted person, as being barbaric, uncouth, uncivilized, and unethical, arguing that he is merely a person of interest. But will this position hold legal weight to break down the issues and help us understand and properly situate us? I have been joined by a former Attorney General, Joseph Ni Aikwe-Otu, who will help us understand the legal implications and whether the actions being taken by these key institutions of state align with Ghana's constitutional and democratic principles. This is Upfront. My name is Raymond Acquah. You're welcome very specially to Upfront. I'm very grateful that you're able to join us this evening. Yes, if you could unmute, certainly I'll hear you better, sir.
Good. Is that okay?
It is perfect. Now, let's start from the new NDC government's directive to all public sector workers engaged after December 7 to be sacked. From a legal standpoint, does the government have the power to issue such a directive, sir?
Well, thank you. First of all, I think it is premised on the fact that they think perhaps things happen after 7th January. And that is an onus which will be on them. The government was elected for 4 years. It will lose its authority only after midnight of 6th, entering into the 7th. So it can do anything until that day, when the new president is sworn in. So until a new president is sworn in, I do not see any law which is mightier than the Constitution, because it is the Constitution which is the fundamental law which we have to obey. So if that fundamental law says that you be in office until midnight of the 6th and immediately we enter 7th of January, your powers are gone, and you've done all that within that period, to me, there is nothing wrong with it. As we have just laid the premise, what it means is that, therefore, he has no authority to continue to be employing people or acting on behalf of the government of Ghana. They wouldn't have that authority.
Okay.
So if they are able to show, first of all, that these things happen after the 7th, but that would be a very tall order, because everybody might have to produce their appointment letters. And the dates on the appointment letters, I have no doubt in my mind, will show how the date on which they were appointed. Now, the Constitution, it also tries to protect, what do you call it, public servants, because of these same things. so that you want to have a situation where you should be able to prove that the person has really done something which warrants your removing him from office. And if you are not able to do that, then I'm afraid it will be difficult for you to say they should just go home. So let me look at the public services in Ghana,
Okay.
which comprise the civil service, the judicial service, the audit service, the education service, prisons, parliamentary, health, statistical, national fire service, customs excise, internal revenue, public service, police service or immigration, legal service, public corporations other than those set up as commercial ventures, and public services established by this constitution, and such other public services as Parliament may by law establish. So I believe these are some of the institutions that they are looking at. Now you look at, that is Article 190. Now when you come to Article 191, it provides that a member of the public services shall not be victimized, discriminated against for having discharged his duties faithfully in accordance with this constitution, or be dismissed or removed from office, or reduced in rank, or otherwise punished without just cause. So if indeed you have, the person has been appointed, properly so-called, then you have to contend with this article of the Constitution. You may have to contend. In other words, you may have to show just cause.
Okay.
Are you okay?
I get your point. Now,
so if there is just...
Okay. Yes, sir. Yeah, you are speaking, sir.
Go on.
Now, I asked a question because in the statement that was put out there by the Chief of Staff, there is specific reference to, and I read that, I wish to bring to your attention that the appointment and recruitment made in the public service of Ghana after December 7, 2024 are not in compliance with established good governance practices and principles. That is what the Chief of Staff is grounding this decision on. Good governance practices and principles.
Well, what does that mean? Are those letters or that letter he has written weightier than the Constitution?
Will this stand scrutiny?
What the Constitution, is that not what we are bound by, or we are bound by his own whims and caprices? He has decided to write a letter giving an excuse, and I'm telling you that under the Constitution, you cannot remove a public servant, dismiss him from office, or reduce him in rank, otherwise punish without just cause. Instead of looking at just cause to say that there's no just cause, we are talking about good governance. Is that what the Constitution, is that a criteria for removing and dismissing people?
Now, some have made reference to this practice being what happens consistently. They have gone back in time to reference those. But is that justification for what this letter seeks to do?
It's a way you have constitutional provisions which you do not respect, or people don't take them serious to the extent that wrong things are being done and nobody tries to challenge, then that's what will happen. Oh, by the way, but who put this Joseph there? Have you seen me write my name with Joseph before? Are we not independent enough to have our own names?
Me, I have instructed they take it off with immediate effect. Yes.
Yes, I did.
Okay.
So I'm saying that. So it's like Trump. Trump decides that he's going to sign an executive order that even if you are born in America, you do not have citizenship by birth.
Okay.
And so he issues an executive order. Then people immediately go to court, and then they stop him that this is the constitutional provision, and you cannot use an executive order to change it. I will tell you that you can use the same precedent. He cannot use a letter to be talking about so-called good governance when the Constitution says give a reason before you can remove that person. Secondly, as I said, basic thing, basic principle. How do you prove that as at the time the people were, what do you call it, recruited, the person who acted did not have authority to do so? These are the things. So people should just get themselves ready to go to court. That's all.
I've heard members of parliament, including that of Otafo and others, including the NPP's national organizer who spoke earlier today, indicating their willingness to compile a list and lead the people to court. Would that be a step in the right direction?
Of course, I have been contacted previously, and I said I want to see the letters.
Okay.
I haven't seen any letter. The one who contacted me was from Ghana Water and Sewage. Also, I haven't, the Ghana Water Company that said they have been there. They were recruited in September or so, started work sometime in November, and now they are also being accused, of certain. So, as I said, the onus of proof will be on them, because anybody who has an appointment, the basis, the contract of service between you and that employer is your letter of appointment. So they will produce their letter of appointment, and we'll all find out the what do you call it, the effective dates, and we'll take it from there.
Now, are these situations different from the removal of CEOs of state institutions, which has become a pattern after political transitions? Is this because you mentioned the civil service and mentioned the public service, and you mentioned the other services? If, say, I am the CEO of, let's say, state insurance company, am I equally bound by these provisions you mentioned, or that's a different kettle of fish?
They're different kettle of fish. Some of them, government has shares,
okay,
like SIC. Not many people know that I was one time the board chairman.
Oh, I see.
And then we lost power in the 2008. So sometime in 2009, the CEO called and said, well, Honorable, we are sorry, but we have received letter from the office of the Chief of Staff that all those who were appointed by the previous government should have to give way. I asked them how. How so? Because government is not it's not like state enterprises or SIGA, where government owns everything. But this one, government only owns a part of the shares. And so what happens is that after the nomination, we are presented to the shareholders, who then confirmed and approve all of us at an annual general meeting. So wherein comes government to say it is removing me? Well, I'm a serious legal practitioner. I have something to do. I don't have time for this. I'm going to leave. Now, if you remember, Sambo Kujato said no, they were removing him from back of Ghana. He said no, they couldn't. He has his whatever. So he went to court. Now, subsequently, I do recall that others also went to court, and the court made it clear that they cannot just be removed like, ordinary individuals, because government actually does not own all the shares. They are accountable to their shareholders who approved of them and put them there. And they gave them contracts. So how do you just come and decide? I mean, I'm told, for example, SIC, government has only 40%. What about the 60%? Government is even a majority lead shareholder, and it wants to appoint the chief executive or what is that? But, so I think there has been a clear distinction already that where the people, government only owns shares and the rest, and then the others are owned by, the majority are owned by shareholders. Whatever they have decided, unless there are grounds under the company's code to remove a board member, to sack the CEO and the rest, it's not open to government to just take over and then come and do the things that they do. So I thought we have all learned our lessons.
Very well. But what happens is that there is some form of a transition period, a conversation, which, because even the threat to take on this matter in court by the SICMD was withdrawn. I think she filed and withdrew the case subsequently, so that she has now finally handed over. But the question many are asking is whether or not a natural transition of this sort, or a wiping out of people who might have even been recruited by a certain stringent process, is still in the good or best interest of this country.
It's always good to test the law. So if somebody is testing the law, and then pressure is mounted on that person to withdraw. I remember in the Samoku Jato case, Bank of Ghana, they also put pressure and decided to settle with him. So I will not be surprised if they have gone to see the lady to settle. That at the end of the day, some of the reliefs you are seeking is a compensation package for you, because you have served some time and then you are being terminated when your time is not up. So you ought to be compensated. So I will not be surprised. I have not heard about it, but if that is what is happening, I can assure you that they have given you a tidy sum to close the deal so that they can have their own person there.
Now, let me bring in a conversation that has become heavily topical because of the current happenings with former finance minister and his declaration by the Office of Special Prosecutor as a fugitive. Now, the OSP invited Mr. Ofori-Atta for questioning, but has now declared him a wanted person. His lawyer says he's unwell, he's seeking medical care, but the OSP believes that the man has no intentions of honoring their invitation. In fact, they believe that this is an indefinite leave the man is off outside the Republic of Ghana and has no plans of returning. They first said he's wanted and proceeded to say he's a fugitive of the law. Some are immediately questioning the decision to put these things on board. First, can the OSP declare anybody wanted and also a fugitive of the law? If you can hear me, sir. Well, I seem to have a slight challenge with the connection to Nia-Iko today. We are dealt in this conversation with more recent happenings, especially from the NPP's press conference earlier today, addressed by Henry Nana Boakye. The very first two issues he raised were in connection with the decision by the OSP to declare Mr. Ofori-Atta a fugitive of the law. We also have, that's just what we were getting to. But we'll take a break. After the break, we'll be delving with this matter and also the other controversial matter to do with the powers of the Attorney General, as he appears to be on a roll with ending or withdrawing some of the cases that his predecessors were dealing with. That we'll also hear from Nia-Iko Otu on after this break. You welcome back to UPfront. My guest tonight is a former Attorney General of the Republic of Ghana, Joseph Nia-Iko Otu, and he joins me via Zoom now for a conversation that we'd already be having in here. We started with actually talking about, first, the decision by the government of the Republic of Ghana to ask some workers who were recruited after December 7 to go home, or to disappoint them, if you want to call it that way. We also jumped into the conversation about CEOs who are leaving office and are having some form of arrangement with government to do so. Now, we are jumping into another leg of this conversation, because that's part of the conversation that the NPP in a press conference earlier today raised. It is about the statement from the Office of Special Prosecutor. And this statement has generated concern because when the Office of Special Prosecutor did this press conference, it categorically stated that Mr. Kenneth Nanaya Kuntunkunuku is a wanted man. That is our former finance minister. is a wanted man. Not only is he wanted, he is also a fugitive from the laws of the Republic of Ghana. The lawyers of Mr. Ofori-Atta and the NPP in this press conference today, and what was said in Parliament, insist the man is seeking healthcare outside and is unwell. Now, let me start from the basic element of asking you, thankfully for joining us again. Ni, is it possible? Can the Office of Special Prosecutor declare anybody, one, a wanted man, two, a fugitive of the law?
Thank you. It seems to me that in view of the difficulties that he keeps having with some of these things, it will be better for him anytime he acts to show us by what authority is acting. And therefore, before anybody could say anything, at least he should have preempted and said that, look, I am acting under section so and so of the Act, and I think I have the full authority to do so. Otherwise, you let everybody, you leave people with the assumption that perhaps you are not, you are just acting without, any basis.
Okay.
I've tried to open his law. I've been a little busy today, but generally, the object of the office is to investigate and prosecute specific cases of alleged or suspected corruption and corruption-related offenses, recover the proceeds of corruption and corruption-related offices, and take steps to prevent corruption. In the course of doing this, the first I read was objects.
Yes.
Then you have the functions.
Okay.
So to achieve the objects, the office shall investigate and prosecute cases of alleged or suspected corruption or corruption-related offenses, investigate and prosecute allegations of corruption, investigate and prosecute alleged or suspected corruption, recover, manage, disseminate information, cooperate, receive, If these are his powers in terms of investigation, then it will be like any other police investigator who is investigating a matter. And therefore would have the right to invite people, to appear and then give evidence. I have just opened the law, and I don't see that maybe he has the power to also arrest and in the course of investigation, of course, that power will be there. But to declare people wanted, you declare somebody a fugitive who is running away from justice.
Okay.
In other words, that is aware that is facing, some investigation or some trial, and he has run away, he becomes a fugitive. Now, in the peculiar circumstances of this case, from what I've heard, I have not listened to the press conference by the NPP.
Yeah.
Listened to that one because I've been very busy today. I just came back from town.
Okay.
I'm told that the lawyers informed the office that it was outside the jurisdiction seeking medical attention, and that he would make himself available immediately he finishes whatever he's doing there. So in those circumstances, do you think that person is a fugitive? Don't you know where he is? A fugitive is somebody you don't know where he is, isn't it?
Oh, yes, certainly.
His whereabouts are unknown. But if they have told you where he is, and he says, I am receiving medical treatment, but I'll return very soon. Immediately, my doctors give me the go-ahead. Then what is it that you are doing by declaring him wanted, that he's running away? In other case, hasn't he got the right to self-incrimination? that he doesn't even want to give you any statement. The right to keep silent, is it not a constitutional right that he can decide to remain silent? So why don't you go on with your investigations instead of saying that he has run away when you have not concluded and you have not charged him with any offense, but you rather are waiting for him to come and say things for you to have a basis? When we started criminal practice, one of the first things we learned is that the accused can say that he is putting himself on the prosecution to prove him guilty because he has no burden to prove that he is innocent. The burden remains throughout the trial on the prosecution. So if he wants to prosecute someone for corruption or corruption-related offenses, he must gather the evidence. Why does he need the person's assistance to do his investigations? His assistant is rather to exonerate himself.
Okay.
To tell you that even what you are saying, they are all not true. This is not what happened. This is not. So if you have your evidence, go ahead. Why should you declare him a fugitive from justice when he has not been charged? He's not facing any offense. He's not standing trial for which he has been granted bail and for which he has run away. You understand the issues I'm raising.
I get your point.
So it becomes a little worrying that because the person has a right to remain silent. So why? Is he obliged to give you any evidence? Now, if you look at the article...
You don't think he's obliged to give evidence? You don't think he's obliged to even attend upon the invitation?
Article 19:11. No, 19:10. No person who is tried for a criminal offense shall be compelled to give evidence at the trial. Even when you have charged him and you are trying him, you cannot compel him to give evidence. And you are gathering the evidence and you are saying he should come. He tells you I'm not well. Go ahead and do your investigation. Charge him. If he doesn't come, try him in absentia. Sentence him and repatriate him from wherever he is. Okay? So why should his attendance upon you be an issue that you go about declaring him a fugitive? I hope you have appreciated the point I'm making.
I get your point 100%. What you're basically saying is that Mr. Ofori-Atta is not under any obligation to cooperate with this OSP, and that the OSP can go ahead and do its investigation. But the OSP says it will deploy all the available skills, powers available to it to bring down Mr. Ofori-Atta to come and face justice.
Yes, so you charge him. Conclude your investigations. You don't use him to gather information. Gather your information, conclude it, and then charge him and tell him that, look, you are expected to be in court by a certain date. If you don't come, the trial will go ahead, your absence notwithstanding. I remember going to court against, was it those guys who bought the Mercedes-Benz? What do they call that one? The former guys who bought this Benz and they were not paying.
Oh, okay.
Do you remember? I've forgotten the name company.
You mean the company that does that? Yeah, the company.
And I went to court. I even granted an interview saying that the one who is not well can be brought because he's within the jurisdiction. We want to take his plea and go on. You understand? Mm-hmm. So what he's doing me, I don't understand it. You should go ahead. People are always tried in absentia. Haven't we tried people in absentia since we came to power?
Yes.
We have done that. So you can try people in absentia. You should go ahead and stop disturbing this whole idea of playing to the gallery, if you like.
Indeed, Ferdinand Tamaklo Ationi was tried in absentia. She was outside this country. She was actually jailed And I understand she's still outside this country anyway.
Yeah, he hasn't come back.
Yeah. Now,
is it the mascot somebody or something
yes,
like that?
former mascot CEO, yeah. Now,
well, they tried to act in absence. Hasn't he heard about that before? Why does it make the whole thing look like it can't happen without the guy? You've not even charged him with any offense. He's like to come and help you. Meanwhile, he has a right, even when you charge him, constitutional right, not to give evidence. He ought to know that. So what is all this?
Now, the related point is about he saying, that is Mr. Foriata saying, his lawyers will provide the information in the interim until he's able to return. Should that equally suffice?
I'm saying that he's not obliged to go to the OSP and give evidence. You are investigating. We just read his functions. And he is to do investigations. What he's asking him to do is to come down to help him to conduct his investigations.
Okay.
And I'm saying that even the Constitution is saying that when you have charged him, he can keep quiet. So can't he adopt the same strategy and say that I will not collaborate with you, go and gather your own information and charge me? You are to investigate and prosecute the case. In all this, investigate and prosecute, and then recover.
Yeah, that's very interesting.
What oral is doing, recover.
Okay.
If you have any evidence and all that. So please, I do not think that he is going according to what the law says him up to do. Or at this stage, unless you have, as a pressman, you have picked from some information which I don't have. All he's doing is investigating, and he wants him to help him to do his investigation. That's all.
That is what they have told us to. There is no further and better particulars provided beyond that.
Yes. And if a person constitutionally has a right not to give evidence, why is he obliged to come and help you to gather evidence against him? Meanwhile, we are told that a person can refuse to answer questions which would incriminate him. Is he not aware of all that? So go ahead and do your investigations. Who is preventing him from doing his investigations?
Now, it is the view of Leonard Kwaku Ansah that the conduct of the OSP rises to the level where he should resign. Is it something you think is a step in the right direction?
Well, that is his opinion. I mean, when you are given a public office, you are bound to make mistakes.
Okay.
At our ages, we are not to just condemn, we are also to nurture. So you can always advise. I remember when he took to these press conferences complaining about his office losing cases. I said, as a former Attorney General, I don't think it's proper for him to be doing those things. I would advise that if he's not, if he's dissatisfied or aggrieved with a decision, what he has to do is to file an appeal and test the law. You don't take to the press. What do you expect the press to do for you?
Okay.
Is it the press which can condemn the High Court and say that you err in this matter particular? Is it not the Court of Appeal that can do that? And then you set the precedent, and next time with something of the nature occurs, you will have a precedent to fall back. But you don't rush to the press and make you judges, make you judges of appeal, and then talk to you, he has become Uncle Nam or whatever. He should go on appeal. That is an advice I gave him. In the same way, I'm telling him that your duty is to investigate and prosecute. Look, the Attorney General's department, we don't do investigations there. When I was Attorney General, anytime something happens, the press would put my picture on the front page, then bring the story, and then ask, will he act? Will the Attorney General act?
Yeah.
I got incensed and I asked them to write a rejoinder that they should stop those things. It is the police. It is the province of the police to investigate and build a docket. When they've finished, they bring the docket to the office of the Attorney General. Then I refer it to the Director of Public Prosecution, who is head of the Prosecutions Department. Then they would look at it, advise me as the Attorney General. I would now look at it and I said, no, don't go ahead. I don't think we have sufficient evidence to go on. Or I give them the go ahead, come on, tell the police they can proceed to do investigations if the trial is either at a magistrate court or a circuit court. But if it is high court, then I ask them to go and do the prosecution. So we don't do investigations. The dockets are built from the police and brought to us. There was a time, during my time too, there were all these arguments that, we have sent the docket to the agents department, we are waiting the agents' advice. I realized sometimes it was a ruse on the part of the police to find an excuse why they are not investigating. So I liaised with the IGP and I decided that he should give me a liaison officer, a police officer from the police service who will come to be attached to the DPP's office. When they have dockets, he should bring the dockets to the DPP or our office. It will be receipted. When we finish, we give it back to him to take it to them so that we'll stop all this, if you like, nonsense of police saying that the docket is with the Attorney General and we are waiting. I did that. I don't know whether they are still doing that, but that is the way to go. They build the docket and forward it to the office for advice. So he should, if he thinks he cannot do the investigation because he hasn't got the personnel, he should rely on the police to do the investigation, build the docket for him, and then he can embark on the prosecution.
Can his conduct be perceived or construed as political harassment? This is what the MPP is basically saying.
Well, I am a member of the MPP. There are times we all play politics. Sometimes you also want to hit them hard, and you could see it along those lines, make him hot small, say some things about it. Yeah, so it's fair, it's okay. I mean, if you are a public officer and you don't develop a thick skin, then I don't see how you can be a public officer. You develop a thick skin. We are always abused. I mean, when you do these programs and you open it to Facebook, you see the comments coming. Sometimes you are on it doing the program and people are abusing you left and right. You just have to forget about it and go on. You develop you have earned the right, to be called upon to educate the public.
True. If
there are some Ramoses somewhere who think they will take the opportunity to abuse you, your grandchildren, I'm over 70 years, so grandchildren take to Facebook and decide to abuse, and the things they are saying do not even make sense. Why should the Ghana people say, man, they chembotu? I won't mind them.
Okay, very well.
So he should also have a big heart, and I've held so many offices, secretary, national secretary of the bar, president of Greater Accra Bar. You always have problem as a leader. People will, accuse you. So even when they say you should resign, you don't think there's a need for you to resign. Why do you resign?
No, that's an interesting perspective. But since you already mentioned your role as Attorney General, the current occupant is already under fire for some of the decisions he is taking in the early days. These are in the area of withdrawal of cases and null prosecutors. Indeed, some of the most prominent ones, and he's been responding to them. Let me take your view first on this matter. It is the settled practice and direction of the Supreme Court that the Attorney General is not under any obligation to explain why he files null prosecutor to anybody in this republic. Of course, to the public in this area. Dr. Ine says he disagreed and is doing something different. Is that a laudable step?
Pressure was put on him to come and hold the press conference that he held. It was not voluntarily. he would have taken the same step that all other attorney generals have taken, that they are not obliged to give any explanation when they enter a nolle prosequi. But a lot of pressure was mounted on him. I've told you already that when there are constitutional provisions and we don't resort to them, then we allow the constitutional provisions to go waste. What happened was that I had even given an interview already to draw his attention to Article 296 of the Constitution, that the days when people did whatever they liked with their discretion are long gone. And that with Article 296, you now have to explain yourself as to how you have exercised a particular discretion. And I read, where in this Constitution or in any other law, discretionary power is vested in any person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of that discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with the process of law. So he did nothing. He has not done anything out of this. So he was called upon because people are now wide awake. I am one of them who read this on air and told people that he cannot think that he shouldn't think that it is business as usual. Of course, when I was there, the Constitution was in force, but nobody drew attention to 296. Now we are holding him accountable that the sections under the Criminal Procedure Act, which gives him that discretion, are inferior to the Constitution. So when there are provisions in the Constitution, he is bound by the constitutional provision. Anybody who is aggrieved can go to court. Anybody who is aggrieved by what he's doing can even go to the Supreme Court, to find out the constitutionality or otherwise of those provisions of the Criminal Procedure Code, which says he can exercise an absolute and arbitrary, discretion of just trying to try some people, and in other cases, decide that others should walk free. So he has not done anything. He has only listened to the calls for him to be, fair and candid, and not to exercise it in an arbitrary, capricious, or biased manner, either because of resentment, prejudice, or personal dislike. And it should be in accordance with the process of law. That's all he has come to do. He is not disagreeing with anybody. He's only come to obey the dictates of the Constitution.
Interesting. Now, let's drill down to some of the cases that he came to explain his decision to file nolle prosequi. Some of them were very high-profile ones, like the one currently on your screen, the high-profile case dropped in connection with the charge of defrauding by false pretenses, willfully causing financial loss to the state, corruption, and money laundering. This was related to the activities of procurement of unapproved and substandard fertilizers to Cocoa Board by Dr. Stephen Kwabena Opuni, who is a former CEO of the institution. Now, that is there. There is also what's also controversial, the Saglemi popular matter. The governor of the Bank of Ghana's case is also come up. If you review these cases, and to you, which of his justifications does not truly sit well with you?
It doesn't seem to have. He's only been playing the role of his master, the president. That is all there is. High-profile cases, everybody has interest in them. You cannot tell me the president is not interested in those things.
Except he stated categorically that these decisions were taken without consultation with the president. He will subsequently brief the man.
That's the point I'm making to you. Do not believe him.
Okay.
Because people are saying that the president, he has also become, JM has also become a clearing agent. He wants to shield him. But he cannot take such a decision without reference to the president. These are high-profile That's why we call them high-profile cases. We have all been there before, and we know how to deal with high-profile cases. So what he's doing, they are all appointees of the president. Most of them are appointees of the president. So he knows them, and he doesn't want them to be prosecuted. That is all. Some of the reasons I'm not interested in them. I mean, how do you say? Every
I'm afraid
any law student
I am
has
losing.
been taught that if you charge somebody, if you charge with having stolen 1 billion, by the end of the day, you were able to prove that the stolen is for not a 1 billion. So agreement and what he was engaged. Where is it coming from? I think you are doing law or you've done some law. Didn't you come across it? That if you charge somebody with 10 billion and you prove only 100, you only punish him for the 100. So what is this idea that somebody is being asked to work because the figure was higher? Why? We all know this in criminal law. It can't be. So like somebody asked him yesterday, a lot of money has been sunk and the thing has been left sitting there. He's not holding anybody responsible. Now he says, okay, we have to look at it and come back again. Nobody is being held responsible for all the wastage at Sagleme. Is that what he's telling us?
His exact justification.
Look, one of the first high-profile institutional appointments was Randy Abbey, isn't it?
Yes, Randy Abbey to Cocoa Board.
Yeah, who put him there? So who put Opuni where he is? If you think, if he's facing difficulty and you are back, you don't want to assist him. Oh, please. I said I have been there before. It's quite a very simple thing to do. When your government comes to power, stop all those trials. Look, if you have followed what is happening, I'm sure that you know that all that the lawyers did was to play delay tactics. Anytime the court makes a decision, an interlocutory appeal will be filed against it. The appeal, and then they ask for stay of execution, stay of proceedings, first to the court below. They will take a date to deal with that one. When it is refused, then they go to the appellate court, repeat the application again, and things like that. So all they were doing was to ensure that the 4 years will pass. Fortunately for them, another 4 years passed, and that's it. And so they have achieved their aim, and that is why immediately he was sworn in, within a week or two, he decided asking all of them to work. Just work free.
Is it fair to state so? For example, in the Sagleme case, the Attorney General stated that he's not disposed of everything. He's looking at the matters keenly and will make sure he gets to the bottom of it. Is that some assurance to you that this is not being thrown away completely?
Against who? Against who? Who is the high-profile man who has worked out? Who is the high-profile man who has worked away?
I mean, he actually...
Which one do you know? Which one do you know in the NDC who has just walked away or worked free?
Collins Dowda, for example.
Yes. Who are the rest that he wants to look at?
No, he says that the matter will be dealt with in full, so he's looking into details. In fact, he mentioned not just Collins Dowda. He said others equally made payments. I'm quoting specifically. Said the prosecution in the case also failed or neglected to take into account payments that were made by other ministers who took office after Collins Dowda. For instance, the Honorable Atachi, as Minister of Works and Housing, approved the payment of $5 million in 2017. That ought to have been considered in determining the value of state funds that the Honorable Collins Dowda has misapplied.
So he wants to add others to the charge. In other words, he can add them.
Okay.
He can amend the charge. He can withdraw and just replace it with a new one, adding other people to it, instead of entering an only prosecute and going home. We are here. Let us see whether it will bring back that gentleman. I'm saying it's just well calculated. Or you think Ofuswan Pofu, a party chairman, should be facing trial during their time? Oh, my brother, I say it won't happen.
Is it not justice?
Why didn't they allow?
Is it not justice? Is it not Minister for Justice? Justice for the People's Republic, justice for the accused and everybody involved.
You see, why you bring in the justice?
Yes.
That is rather what worsens the matter. If you're an attorney general and you are not a cabinet minister, then we can assume you are not a politician, isn't it?
Okay, yeah.
But when you add a minister of justice, what do you think it has become? Is it not one of the ministers like others? So you think he doesn't know his politics? He's doing politics. He knows how to do politics. But when you bring an attorney general, who is not a cabinet minister, who does not hold any ministerial appointment, and you ask him to do his job, fine. But once you have a minister of justice and attorney general who goes and sits in cabinet, and that's all the things that his party wants, and brother, these are throwing dust into people's eyes. That's all. We are challenging him. He should go and bring the Dauda again. He should bring Ofuswan Popo. He should bring those they appointed who have all been asked to go away.
I'm grateful to you, sir. Ever distinguished Ni Aikoto, former Attorney General of the Republic of Ghana. And I'm grateful to you, distinguished brother.
You're welcome, my brother.
Well, that's where we end today's edition of UPfront.